University of South Carolina School?
Environmental and energy law. So I taught environmental law last semester. I'm teaching energy law and a seminar on climate change this semester.
Great. Do you do purchase stuff?
I do in energy law. Yeah, I'm really looking forward to it. Yeah. Oh, it's maybe it says more about me, but I think it's fun and interesting.
That I was involved in one project,
That's one of those things you do
a
really
couple of
like.
projects, which I actually one was on foreign direct investment.
It is.
Sector. The other was
I also teach administrative law. Talking about how government works is fun and like.
fascinating place, but it was some stimulating experience.
You know, the way they figure out all the rates.
Mm-hmm. Yeah, I do know what you mean. My colleagues is like ERISA that do like the benefits calculation stuff. I feel exactly what you talked about for regard to what they do, but they love it.
I have a couple friends who were on it. And they loved it.
Yeah. Yeah, I've got a good friend that was a staff economist there for a long time. He's in private practice now, but he loved it a lot when he was there. You can stand or sit either.
I'm gonna speak up there. It's just easier for me to.
Whichever you prefer. Some this more, as you've seen, some do it, some
Yeah,
don't.
How's your thing going here?
Good. Good. It's a little slow starting. People will get here and Metro go and stuff, but it was good. Hi.
What is the order of the speakers for this panel, so I can know for the PowerPoints? Okay.
Tricia. And Bob.
Okay, so the two PowerPoints are first.
Yes.
Okay, excellent.
What's that?
It's a little bit of a draft.
Yes, we've had previous speakers complain about being cold. If you want to get your code, it'd be easier to do it now than later.
I'm not.
Okay.
Thank you.
We'll get started in just a couple of minutes once some more folks, including our organizers, come back from lunch. I have not. This is the first time for me. I actually just joined South Carolina about 18 months ago.
Where are you
I
based?
used to be at Resources for the Future with Alan.
Wales in the UK.
Mr. Blackman?
So we did
I
our own
see
events.
you also have a PowerPoint, actually.
Somehow everyone
Okay.
else.
And it's on.
Yeah, I see it right there. So I'll bring it up now.
I liked where it was at Archive. I missed that too. But Columbia. Yeah, we do. We got people come through to stay a lot.
I hope you're not flying back in the morning.
Okay, you familiar with that? Yeah. It sounds like it would be cool to be in that state, but I'm sure you like get tired of it. I will be. I'm going to be lax on the time for the total panel. I'll let the organizers run that. Basically, I let them tell me when like, we're done.
I just want to quickly introduce myself. I'm Joel Samuels. Thank you so much for being here.
Glad to do it. Thank you for the invitation.
Have they already told you about John Cruise's remarks earlier today? In his remarks, he said, see you come back on this one. Tricia, I said Patty Beneke and
Know that I enjoy
Jay
it.
Beneke. So there you go. So,
What a nice guy.
and then, pressure heat on the shoulders.
Well, he's a good guy. He's an old friend. So thank you.
Moving forward.
Start at time. EPA for.
What's that?
You can start at time.
Okay.
For the,
Yeah. So I will give you 20 minutes. I'll give you a warning at 5 and at 1, and I will cut you off at 12. Other than that, you guys whatever you want to do, whatever you just.
don't be shy to say something because we're not noticing you holding up the card. Just say it.
Okay. Okay. Good. I'm glad it was. So I'm gonna go ahead and get started. Ethan. Sure. Ethan, you'll go first, then Tricia.
Got my bio.
do. Okay. I'm gonna say a little bit about getting, and then we'll just go from there. Okay. And make sure you talk. Good afternoon, everybody, and welcome to our final panel of the day. My name's Nathan Richardson. I'm a professor of environmental and energy law at the University of South Carolina. This panel will be on environmental governance and the rule of law, and in many ways, this is, of course, the core set of issues that the other panels we've had have touched on. We're going to look at a variety of questions, but ultimately, something that we ran into this morning, no matter how good the laws and policies that you have designed by the best lawyers or economists and policymakers, that doesn't matter so much if enforcement isn't there, or to take a broader view that the best laws and policies have to take rule of law into mind from the start. And I think we'll see some examples of that, some specific examples from our speakers today. I want to thank the Wilson Center for hosting us here. I want to thank my colleagues at the Rule of Law Collaborative for inviting me and everyone else to be part of this. And of course, I want to thank you for taking the time out of your day to come see us. So I'm going to do some brief introductions of our four speakers today. I'll do some very brief ones up front, and then we'll go through those four speakers and then have some time at the end, of course, for Q&A. That format's probably familiar to you by now. Okay, so we have four panelists, and I'll read them. I'll talk about them in the order that they'll present. First, we have Ethan Schenkman. He's a he's the Deputy General Counsel at EPA. We're very lucky to have him today. He has a long career of government service, including at the Department of Justice, Environmental and Natural Resources Division, where he was a Deputy Attorney General and had a number of other roles as well. He's also served in private practice and was a Court of Appeals clerk at, I believe, the Fourth Circuit. So we're certainly looking forward to hearing his remarks. Next, we'll hear from Patty Beneke, who is the Director and Regional Representative of the United Nations Environmental Program, the UNEP, at the North American Regional Office. She also has a long and distinguished career in government, formerly at the Senate Committee of Energy and Natural Resources, and then also at the Department of Agriculture, Department of Justice, and Department of Interior. She's also and she's also taught at a variety of law schools, which of course makes it easy for her to get along with those of us, the many of us here that are law professors. We like that. Okay, next we'll hear from Ngobo Emesa, who's had a long and distinguished career both in Nigeria and in the United Kingdom. She's currently Director of Postgraduate Studies in the Department of Law and Criminology at Aberystwyth in the United Kingdom, where she's a lecturer. She's previously been a barrister and solicitor at the Supreme Court of Nigeria, in addition to a variety, again, of academic positions both in the UK and in Nigeria. And finally, we'll hear from Alan Blackman, a former colleague of mine at Resources for the Future here in Washington, D.C. He's the only economist on the panel. For a long time, I was the only lawyer, and among a bunch of economists at RFF, now I get to turn the tables and make an economist hang out among four other lawyers. I hope it's as much fun as I think it will be. In any case, he was a great colleague when I knew him, one of the best economists I know, focuses on development economics, environmental economics like all of RFF's economists, but specifically on development economics. He's a senior fellow there at RFF and is the liaison between RFF and the International Environment for Development Program. He has a wide range of research on pollution and other issues, especially in developing countries, and of course we're looking forward to hearing from him as well. Ethan, you want to take it away?
Thank you, Nathan, and thanks to the University of South Carolina and is this on? No. And the Woodrow Wilson Center for the invitation to be here today. I'm with the EPA's Office of General Counsel. We have about 165 lawyers here in DC working on all facets of EPA's programs, and a number of lawyers around the country as well. But in addition to lawyers that specialize in different media, like air law, water law, hazardous waste, we also have a practice group that focuses specifically on EPA's international activities and international law and international environmental law practice group. And we have several of those folks here today. I hope you have a chance to meet them, who've been working on these issues for some time. And that practice group, along with another practice group that focuses on Native American issues, our client within the agency is the Office of International and Tribal Affairs, OIDA. And so we have specialists both in international law and in Indian law who work at EPA. And while I'm going to be focusing mostly on our international work, I did want to take a second to comment on some of the really interesting remarks that we heard this morning. And I thought the theme of indigenous rights is one that I wasn't necessarily expecting to hear this morning. It wasn't on the agenda per se, but it really struck me how integral the issue of indigenous rights is to the issue of rule of law and environmental governance. It certainly is at EPA. We, for example, have a very robust Native American consultation policy where, and this is related to themes that we heard this morning about prior informed consent to some extent, that before EPA takes any actions or makes decisions that could affect tribal communities or tribal interests, we have a policy of having a government-to-government consultation with the Indian tribes who are potentially affected. And that's about giving voice to communities, but it's also about respecting the rule of law. In our country, our relations with Native American tribes are governed to some extent by treaties that the United States signed with Indian tribes back in the 18th and 19th centuries. And as part of our responsibility to Indian tribes, we in the federal government pay attention to the treaties that we have with them and incorporate the obligations that we have under those treaties into our environmental decision making. And that's part of the foundation for why we have such a robust consultation policy. So anyway, I thought that was absolutely fascinating, and it certainly resonated with me in terms of our work at EPA. But turning to environmental governance more generally, we at EPA certainly recognize that environmental governance and rule of law more generally is fundamental to achieving our environmental goals, both here and abroad. And with that in mind, we at EPA are constantly looking for opportunities to help build strong environmental institutions and to strengthen environmental legal frameworks around the world. We have bilateral relationships with other countries, and we work under the context of multilateral environmental agreements and multilateral trade agreements that have mechanisms for building capacity and cooperation and collaboration. We have worked with other countries on, as I said, strengthening their institutions and their environmental laws, help improving environmental enforcement, and training judges. And through these efforts, it's become increasingly apparent that we can identify some of the core components of what together comprise an effective system of environmental governance. And I think we've seen in the international sphere a sort of growing convergence on what some of those key elements are. I mean, there's been a number of milestones over the past several years in terms of recognizing and identifying those components of environmental governance. For example, the UN Rio +20 Conference on Sustainable Development back in 2012, which explicitly recognized good governance and rule of law as essential for sustainable development and specified the need for institutions which are effective, transparent, accountable, and democratic. And in the run-up to Rio, EPA and our Office of General Counsel and our Office of International Affairs, we were very involved in working with some of the side groups and preparatory groups to help define the core components of environmental governance. And we've actually, some of us have written several articles, including one by Scott Fulton, former General Counsel and now President of ELI, trying to articulate what those principles are, which I highly commend to you. The second milestone was in 2013 when the UN Environment Program Governing Council issued its decision advancing justice, governance, and law for environmental sustainability, which requested that UNEP support national governments in strengthening environmental governance with attention to several core features, which we heard about this morning. I'm going to talk a little bit more about now. Information disclosure, public participation, the importance of having laws that are both implementable and enforceable, and accountability mechanisms. And that encompasses a lot of different things, including effective enforcement, both civil, criminal, and administrative enforcement, as well as a clear delineation of the different roles that different levels of governments play and how they interact with each other. And finally, the launch of the Sustainable Development Goals in post-2015 development agenda, which includes important language on governance. And I know Patty's going to be talking about that, so I just will recognize that as yet another important milestone. So it's great to see the level of convergence that there's been in terms of recognizing some of the core principles of environmental governance. But of course, what matters is what actually happens on the ground and how it plays out in practice. And so I want to talk about several examples that we've been focused on in our practice group here in EPA with respect to air pollution, which we're very focused on, both in the context of addressing climate change and otherwise. And I want to draw on some examples, both in terms of our bilateral work with China, which is very, very important these days, and we focus a lot of attention on that, as well as some domestic examples. So first, with respect to information disclosure and the power of information. The international community has long recognized the importance of public access to information, going back at least to Principle 10 of the 1992 Rio Declaration. But now, of course, we are in the midst of an information revolution around the world that is pushing information access to an all-time high. Data can be distributed and shared instantaneously, and today there are water quality apps for our phones and other devices, facility locators, sustainability rankings, and even add-on devices for real-time pollution monitoring. And as information increasingly flows from the bottom up, more and more people in civil society are engaged in the environmental conversation. And China is a great example of that. And there's some really interesting and poignant examples that have come up over the past year or so. For example, last year, a television news anchor in China produced a documentary about air pollution that was called Under the Dome, which looked at the impact of pollution on children in China and on her newborn child in general. And it was a hard-hitting documentary. It really struck a chord with citizens in China, provided a scientific and a journalistic validation of a problem that I think people in China have been sensing for a while. And within 2 weeks, the documentary had hundreds of millions of views online. And a smartphone app for mapping pollution that was featured in the film immediately, its popularity just exploded, and there were like over 1 million downloads shortly after that film was distributed. And I think there was some consternation at some political level within China about that documentary, but once it was out, which I think really demonstrates the power of information in this day and age. Another example that also relates to China is what our administrator, Gina McCarthy, has referred to as air monitor diplomacy, where EPA has worked with the State Department to install air monitors on the roofs of our embassies and consulates in China, and starting with in Beijing, to post real-time air quality information that's easily accessible on an app on your iPhone. And when Chinese citizens learned about these readings, their concern about pollution, what I think previously had been referred to as just the fog with an F and not smog, just increased. And at first, again, at the political level in China, there was some pushback in terms of the release of this information, but eventually the Chinese administration came to the conclusion that this problem was undeniable. The cat was out of the bag. And so with the help of EPA and the State Department, they then set up an extensive air monitoring system in Beijing and in dozens of others of cities around China. And now people in Chinese cities are incredibly well informed about, for example, PM 2.5, small particulate pollution, on a real-time basis. Even more so, if you walk around Beijing, you'll see people checking out the color-coded air quality for that day in a way that you don't even see in the United States, and it's really had an impact. Recently, China has amended and modernized its air pollution control law, and the sort of the demand for that environmental legal reform that we're seeing happening in China is at least in part due to the disclosure and dissemination of information. I want to talk a little bit about public participation and the importance of that. And for that, I want to use a domestic example, which, as John Cruden referenced earlier this morning, one of the most important rulemakings that EPA has engaged in is what's called the Clean Power Plan, which addresses carbon emissions from existing power plants. And that's gotten a lot of press, and it's one of the central components of the President's Climate Action Plan, and one of the central components of the U.S. Commitment to reduce carbon emissions that went into the negotiations in Paris. But the point that I want to emphasize about it is the unprecedented extent to which EPA engaged in a public engagement process, a public participation process in the rulemaking, in the development of this rule, where EPA held hundreds of meetings with a huge variety of different kinds of stakeholders, both in civil society and at different levels of government, and got an unprecedented number of comments. I think I've been told that we got as many as 4.3 million comments on the rule. But what really matters is not just the number of comments that we got, but what we did with those comments, and the extent to which the final rule benefited from the intense public input and participation that went into the development of the rule. And for example, we got a lot of input from utilities, obviously, which helped us make sure that our plan reflected how electricity really moves along the electricity grid in the United States. We got comment from sister federal agencies, like the Department of Energy and the Federal Energy Regulatory Commission, to help us ensure that our efforts to reduce carbon emissions would not disrupt the energy supply. I mean, it just goes on and on in terms of the benefit that EPA received from this extensive public participation process. And so it's just an illustration that these elements of environmental governance are not just elements that we're trying to export or encourage other countries to adopt, but are actually very important principles for our own environmental governance in the United States, and are constantly showing how they bear fruit. Accountability. Another core feature of environmental governance is accountability. And this includes having robust enforcement systems so that we don't just have laws on the books, but ensure consistency of application of our laws, and as John Cruden also mentioned this morning, that we level the playing field among businesses, so that businesses that are complying with the laws aren't at a competitive advantage from vis-a-vis businesses that are not complying and are cutting corners. Going back to our work in China, a recent example that arguably illustrates what can happen when you have severe deficits in accountability and in various features of environmental governance, was the tragic explosion at a chemical storage facility in the Chinese port of Tianjin, which involved a warehouse that was located less than a kilometer from residential buildings in violation of a buffer zone requirement. And press reports indicated that company executives had shopped around for an environmental assessment that would allow them to get around the buffer requirement, and used political connections for the siting of the facility. After the incident, something like 20 company and government officials were held accountable. But ideally, this is the kind of tragedy that can and should be prevented from occurring in the first place through proactive steps to ensure that you have key components of environmental governance, including enforcement. How much time is left?
About 4 minutes.
Okay, 4 minutes. One other thing that I want to mention, two other things I'll mention quickly about China, is that in addition to amending their air pollution law, they've also recently enacted a new environmental framework law, which if you want to learn more about, you can take a look at the article that Steve Wolfson and I wrote for the Environmental Forum called China Declares War Against Pollution, where, again, amazing developments in advancing the environmental legal framework in China, as evidenced by this environmental framework law, which, among other things, it expands public disclosure of pollution emissions, it increases penalties for violations, and interestingly, it authorizes NGOs to bring public interest environmental lawsuits, which they sort of had already under the law in China. The problem was the courts weren't accepting the cases. So it's an example of where you can have a law on the books, but if your institutions aren't functioning the way they should, it becomes meaningless. And so part of the purpose of the new environmental framework law was to make clear that the court should be accepting these cases. The Supreme Court in China has actually recently issued a pronouncement re-emphasizing that point, and there have been a slew of new cases that have been filed over the last year, and some of which have resulted in favorable results. So that's an exciting development that we're closely monitoring. And the other reason why I picked China for examples is that I've actually had the privilege of going over there to meet with our counterparts in the Ministry of Environmental Protection, and it's interesting the genesis of why we got to do that particular trip. It was because the U.S. Department of Commerce and its sister agency in China has a rule of law initiative, and they had never really thought about environment within the context of rule of law per se, but it was our Chinese counterparts who said, we think rule of law is essential to environmental protection, and we want the next trip to focus on how rule of law is critical to addressing air pollution. And that's why EPA got involved in that particular trip. And we met, when we were there, we met not only with our counterparts in the government, but with environmental lawyers in civil society, with law students, with law professors, with lawyers who represented businesses. And the level of interest in environmental governance and rule of law issues and in learning from examples from other countries was just absolutely stunning. So there's a real appetite in China that's obviously incredibly important for the future of the planet. We'll see how it turns out. I just want to highlight two other things that are happening in the future with my 1 minute that's left that we're looking forward to at EPA. As I said, we're consistently and looking for opportunities to engage on these environmental governance and rule of law issues. One is UNEP, and Patty will be speaking to some of this, but there's a growing momentum at UNEP to launch a member state-driven process to compile national legal models that countries can draw from seeking to strengthen their own national frameworks and to provide countries with technical and legal implementation assistance with an initial focus on air pollution. That's an example of something that we're very excited about supporting and participating in. And as my last point, I want to mention lead paint. And the World Bank's Global Forum on Law, Justice, and Development we've been working with them on something called the Lead Paint Alliance. And with UNEP, yes, absolutely. And I'm out of time, but I'll say on the lead paint issue, this is an issue that's really low-hanging fruit. The science has been there for a long time about the dangers of lead in paint, especially to children. There's consensus about that. The industry is there in terms of providing substitutes, and what's needed is development on the legal framework side of things. And so we're excited to be working with UNEP and others on that project, which we think will pay enormous dividends with at very little cost. So with that, I'll end it and look forward to seeing what our other panelists have to say. Thank you.
Yeah. Thanks, Ethan. Patty?
Oh, good idea.
Well, hi there. I'm Patty Beneke. As you heard, I'm the Regional Director for North America for the United Nations Environment Program, and I very much enjoyed Ethan's remarks and appreciate that you didn't steal all my thunder, Ethan. We have a great partnership with EPA, as you can tell, and a real commonality of interests, and work well with them on a variety of issues. So I will touch on some of the things that Ethan was talking about, but it was great to hear your insights on it. Sometimes I get myself in trouble doing PowerPoint, so if I get off a slide, let me know, would you please? How many of you know about UNEP? Is everybody real familiar with UNEP? I have to admit, after 30 years of energy and natural resources work here in Washington, I didn't know a whole lot about UNEP because I had always focused on things domestic. We like to say we're the environmental voice of the United Nations, and I do think that that is the case. We have 6 regional offices all around the world, and one is here in Farragut Square. We cover the US and Canada. Our headquarters is in Nairobi, and we get back and forth to Nairobi periodically. We are planning for a big United Nations Environment Assembly in May of this year, where we will bring together all the environmental ministers of the world and many others to contemplate our environmental challenges and help to set the environmental agenda going forward. So it is an important event. A lot of planning goes into it, and a lot of really good outcomes result. I'm going to start out with a quote from someone that you all know of. Any harm done to the environment, therefore, is harm done to humanity. Any guesses? Pope Francis. Pope Francis. These were the words of Pope Francis before the UN General Assembly on September 25th of this past year. And in his historic speech, he, of course, called on the world to address climate change and emphasized all the interlinkages between the environment and climate and poverty. So last year was truly a monumental year for the United Nations and for the environment. And it was, in many respects, all about environmental rule of law. There were 2 huge landmark accomplishments that you've all heard about. In September, on the same day that Pope Francis addressed the United Nations General Assembly, that General Assembly, by acclamation, approved the 2030 Sustainable Development Agenda, comprised of 17 Sustainable Development Goals for the world. And, of course, in addition, the United Nations guided the climate discussions that took place under the auspices of the United Nations Framework Convention on Climate Change, resulting in the milestone climate agreement in Paris this past December. I submit that both of these agreements underscore the enormous importance of the environmental rule of law and also set the stage for great progress on the environmental rule of law going forward. So the Secretary General Ban Ki-moon has had this to say about rule of law. The rule of law is a principle of governance in which all persons, institutions, and entities, public and private, including the state itself, are accountable to laws that are publicly promulgated, equally enforced, and independently adjudicated, and which are consistent with international human rights, norms, and standards. You know, I'm not a political philosopher by any means, nor am I an academic, although I've done a little adjunct teaching. But this subject of environmental rule of law and this panel discussion prompted me over the weekend to crack a few textbooks open. So you have to bear with me because I got into it and it was pretty fun. A few random thoughts here about governance and about why we have and need strong institutions and why we need impartial judiciaries. Plato stressed the need for rule of law as no ruler can be trusted with unbridled power. Aristotle admired balance and moderation and sought a harmonious city under the rule of law. Hobbes, one of my favorites, in the Leviathan, Embrace the role of government as necessary for us to avoid a life that is solitary, poor, nasty, brutish, and short. Locke stressed the responsibility of the government to the governed. He embraced the rule of law through impartial judges. And of course, he had a lot to say about what we call the social compact. So that is the rule of law in a snapshot in general. But let's talk about why we extend it to the environment. Why the environmental rule of law? Well, this notion is not new. For example, the Magna Carta was complemented by what could be thought of as one of the first environmental rules of law, a charter of the forest in 1217, which reestablished the rights of free men to the royal forest. Why is it important that we have environmental rule of law to govern the protection or use of our natural resources? A few different perspectives. You can come at this from the perspective of anthropocentrism. In other words, the natural world is all human-centered, that nature is there to serve humanity. This, of course, would have roots in the Christian Judeo ethic, with man exerting dominion over nature. Utilitarianism, we use nature to achieve the greatest good for the greatest number of people. Even ecosystem services, we think about nature in terms of what it does for us. And of course, we depend on nature for our livelihoods, for our sustenance, for our existence. That would be an anthropocentric view. But there are also other schools of thought. Biocentrism, the environment should be preserved for its own right, in its own right. People like in the United States, Aldo Leopold came up with his land ethic, that there is some intrinsic value in nature and that it's a moral imperative to observe that intrinsic value. This might also, in terms of the mention of indigenous people, people who see divinity or consider nature sacred would perhaps be coming at it from more of a biocentric perspective. And then finally, intergenerational equity. Our dedication to environmental rule of law, I think, can oftentimes be expressed in terms of intergenerational equity, preserving, conserving, and using nature in a balanced way so that we are mindful of future generations. All right, that's enough. That's as far as I got in the textbooks. I will spare you any more. But more recently, environmental rule of law concept has evolved beyond its traditional focus of protecting the environment and managing the use of natural resources. It is now established as a tool for promoting and advancing broader goals like sustainable development. As Ethan mentioned, the outcome document at Rio +20, which was entitled The Future We Want, recognized that sustainable development must address three pillars: economic, social, and environmental. Back in 2000, the goals that the UN nations set for themselves were called Millennium Development Goals. This time around, they're Sustainable Development Goals. That word sustainable didn't happen by accident. It is a recognition that as we develop, we must do it sustainably, and the environment has to be considered. So what are these Sustainable Development Goals? You're probably all fairly familiar. There are 17 of them. They are all interlinked in many ways, and I would submit that the goal on peace, justice, and strong institutions underlies all of these. We're not going to have strong economic development, strong social development, or strong and environmentally sound development without peace, justice, and strong institutions. In addition to being mainstreamed throughout all the Sustainable Development Goals, there are some specific goals that address environmental issues. One would be clean water and sanitation, Goal 6. 1 in 3 people in this world don't have a basic toilet to use. Affordable clean energy, Goal 7. 1 in 5 people don't have access to electricity. Conserve and sustainably use oceans, goal 14. About 7 billion tons of plastic enter the oceans every year. There are goals on terrestrial ecosystems. There are goals on climate change. Take urgent action to combat climate change and its impacts, goal 13. So environmental rule of law is, I think, essential to our being able to make progress on the sustainable development agenda for the world for 2030. So I want to talk for just a minute about Sustainable Development Goal 16, peace, justice, and strong institutions. Like the other SDGs, as I said, this particular SDG demonstrates interlinkages between the three pillars. Rule of law and good governance are essential for progress under each one of the pillars, and all three pillars are essential for our ultimate goal of attaining sustainable development. Rule of law and environmental rule of law in particular also touches directly and indirectly on a range of sustainable development areas, including by furthering inclusive economic growth through the protection of land, property, and other resource use rights, providing access to fair and responsive justice systems, and improved provision of public services. It also strengthens accountability for the development of natural resources, can reduce abuses of power and corruption, as well as attract investments. So each of these sustainable development goals has targets associated with it, and then indicators. How do we measure the progress we're making under these SDGs? So turning to SDG 16 as an example, what are some of the targets? Well, target 16.3, promote the rule of law at the national and international levels and ensure equal access to justice for all. So one of the indicators they were talking about had to do with looking at the percent of overall of unsentenced detainees as a percent of overall prison population. I mean, you can just kind of spin out use your imagination to think how difficult it is to quantify and measure progress and try to come up with concrete specific indicators under each. Another indicator, a percent of seized and collected firearms that are recorded and traced. Target 16.7, ensure responsive, inclusive, participatory, and representative decision-making at all levels. So there's ongoing work on indicators. Targets have been enunciated. But from UNEP's perspective, we think that indicators must be meaningful, scientifically credible, statistically sound, and consistent over time. All right, so some specific examples of what we're up to at UNEP. We have an entire division called the Division of Environmental Law and Conventions. They do great work. They're working all around the world on environmental rule of law, as well as other coordinating with the conventions that are administratively housed, the multilateral conventions that are administratively housed within UNEP. And let me just say, I'm sure that my good friend, the Honorable John Cruden, spoke to you all about a variety of subjects. I'm sorry I couldn't be here to hear him. I would be very surprised if he did not discuss illegal trade in wildlife, because he has been over at the Justice Department doing great work and bringing some newfound international emphasis to that job, and they have been doing terrific work on illegal trade in wildlife, which is a huge problem globally. It is a huge problem in Africa, where elephants and rhinos are being poached. It's a huge problem in South America, where different kinds of aquatic species and birds are being taken. Illegal wildlife trade undermines economies, livelihoods, and good governance. It has in Africa been linked to organized crime and poses a real security threat. So we have been working in UNEP to address this issue. Waste dumping is another problem. Illegal trafficking of waste has occasioned dumping of hazardous waste with stark repercussions. Am I way past 5? I'm just 5, all right. Lead paint, which Ethan mentioned, we have a great partnership going with EPA on this. A few years ago, the United Nations Environment Program and the World Health Organization established a partnership to address the use of lead in paint, in decorative paints, in homes and schools and playgrounds. Over half the nations of the world still allow the use of lead in paint, and you know, it just has devastating impacts, particularly on kids, their IQs, their development, behavioral problems. So EPA has been helping lead the charge on this, and we are going global with efforts to do outreach, education, and capacity building with legislators and others to try to address this issue. Finally, in terms of promoting environmental rule of law, we have a decision 27-9/9, which was subsequently endorsed by, it was started out with our governing council, subsequently endorsed by the UN General Assembly, which gives UNEP a mandate to work diligently and aggressively on environmental rule of law. You probably are familiar with the Bali guidelines, which help governments fill in legislative gaps regarding access to information, public participation, and access to justice in environmental matters. That is based on Principle 10 of the Rio Declaration from 1992. We've had some very important meetings and workshops. There was a forum this past year to discuss environmental rule of law in the Americas, an African colloquium on this topic. There was a high-level symposium at our last United Nations Environment Assembly 2 years ago. We also are in the process of putting together information and guidance material for nations and member states around the world. We have help from some of our colleagues here in Washington, D.C. on this, working on a compendium of environmental rule of law materials at both ELI, WRI is helping us compile more information about the laws on the books and on lead paint. And then, of course, there's training and capacity building, and we have wonderful opportunities to reach out to legislators and others on all of these issues. The judicial training is very important. And UNEP is engaged in all of it. We also are working on the issue promoting the linkages between human rights and the environment. So I'm going to close. I promised I'd be closer to 10 than 20, but I'm a little over, sorry. If 2015 is any indication, I am extremely optimistic about the progress that we can make on environmental rule of law. Certainly in the multilateral context, great strides are being made and need to continue to be made, but it's also heartening to see groups like this gather to consider these issues, and I'll look forward to hearing the other speakers. Thank you.
Thanks. Please join me in thanking Patty. And Gobo?
Thank you very much. First, I'd like to thank the Rule of Law Collaborative and the Wilson Center for inviting me to this very august event. It's a privilege to be here and to sort of just share my ideas around these issues. For my presentation, I'll be looking at some of the complexities around natural resources governance, conflict, and the rule of law, or rule of law and conflict. And I'll be drawing particularly on work I've done around Africa. And I'll be focusing specifically on mineral resources. So that'll be petroleum resources and solid minerals. And it is interesting when we talk about the rule of law and how it contributes to natural resources governance, and how it contributes to conflict, and how the rule of law may be a panacea for these problems. And all across Africa, I'm sure a lot of us would know, whether that be Nigeria, the Democratic Republic, Angola, there have been several examples of conflicts arising from natural resources, particularly in the mineral sector. And clearly everyone says what we need is the rule of law to resolve these problems, that if we have the rule of law, it will resolve these problems. And we kind of have a very common understanding of what we mean by the rule of law. And sometimes it is difficult to actually assess whether or not the understanding of rule of law on the ground in the countries in which this happens, and some of the interventions that are put in place in these countries to achieve these goals, perhaps are totally in line with our understandings in the global West around what the rule of law is. And so perhaps I want to start by reading two quotes. The first is from the past Secretary General of the United Nations, Kofi Annan, in 2003. He said, "The United Nations has learned that without a credible machinery to enforce the law and resolve disputes, people resort to violence and illegal means. We have learned that the rule of law delayed is lasting peace denied, that justice is a handmaiden of true peace." And that clearly, I mean, together with what the quote Patty put up there from Ban Ki-moon, indicates that we need the rule of law to avoid conflict in these regions. And yet, sometimes law itself could be at the core of the problems in these regions. Now, whether or not that is the rule of law as we understand it is debatable. But sometimes law itself could be at the core of these problems. And I have here a quote, and this was very interesting because it was a book I came across as I was researching and walking around these issues. It was published 2007 by Scott Vetch, although I read it in about sometime in 2008, and it's called Law and Irresponsibility on Legitimation of Human Suffering. And he said, legal institutions are centrally involved in organizing irresponsibility, particularly with respect to the production of large-scale harms, including extensive human rights violations, forms of colonialism, or environmental or nuclear devastation. And in contrast to conventional understandings of conventional understandings of responsibility in law, morality, and politics. And what Vetch was saying was, in a sense, we always put forward the solution to problems, conflicts within the context of law. And that once we make the law, then somehow things are going to be right. And his fundamental underlying argument in that book was that law really sometimes within certain contexts is used to promote and in fact sustain irresponsibility. And this perhaps is not new, and we have Marxist understandings around the law and what law is and all of that. But the difference, I think, in Scott Vetch's approach is that he is saying that perhaps when we look at global harms, when we look at harm on a global scale, and we look at the global framework within which law operates, we need to think not just at the national level, but also at the global level. Because what happens in terms of global governance has a lot to do with what also operates at the national level. And so when you look at resource conflicts in the developing world, my area of expertise is around African countries, you do find that law plays a crucial role, both in a historical context and in a current context, in the perpetuation of harm in those contexts. And in discussing this, I want to look at a particular case study, the Niger Delta, because it's one that I've walked around a lot, and perhaps one that we are all very aware of. And perhaps to sort of reevaluate some of the central discourses around the violence in the Niger Delta. And of course, we know that Niger Delta is in Western Africa. It's an oil-producing region. And since around 2005, at least on the international scale level, we've become aware of the conflict that has arisen there as a result of militancy from local communities who contest the role of the state and the operations of the industry in their local communities. And my central argument is that law has played an intrinsic role in the origin of that conflict, in sustaining that conflict. And in a sense, a lot of the interventions that have been put in place have not necessarily addressed the underlying problems within that system. And that is because we've taken a patchy approach to the rule of law rather than a holistic systemic approach to the rule of law. And so perhaps going back to the quote from Ban Ki-moon, and I sort of quickly wrote this down because I've read that before, is that the rule of law isn't just about equality before the law, but it's also about the content of the law. It's also about who makes the law. It's also about how people have participated in the process of lawmaking. And if we reflect on what Ban Ki-moon did say, the Secretary General did say, he said that the rule of law, the laws must be consistent with international human rights norms and standards. Now that seems straightforward enough. But that reminds me of when I first started my first law module, legal system, and we had to learn about customary law and what we call received English law, because I studied law in Nigeria. And we had what we call the exclusion clause for customary law. And what that said was that any customary law that was incompatible with natural justice, equity, and good conscience was not law. So invariably it was subject to that rule. So all customary law was subjected to that clause, subject to natural justice, equity, and good conscience. And the late Professor Elias asks, whose natural justice, whose equity, whose good conscience? Because at the end of the day, we are making value judgments as to what is natural justice, as to what is equity, and as to what is good conscience. And perhaps there is this feeling that there is a common understanding of what equity is, that there is an international understanding of what natural justice is. On some level, yes, but not on every level. And so when you impose and you superimpose some of these international standards within nation states that their traditional systems do not fit in with these international standards, you have a contestation of principles. And often that in itself leads to agitation and conflicts within those regions. And one area that perhaps that comes to the fore very, very clearly is land tenure rights. At international law, and I've been looking at some of the work of Professor John Knox on human rights and environment, UN Special Representative. And one of the debates you have around human rights and environment is whether or not there is the recognition of environmental rights at international law. And when you look at the literature and you look at the judgments of the court, you find that there is a diversity of approach, or rather a divergence of approach between the global north and the global south. Whereas you will find that in the African human rights instrument and in the OS instrument, you do recognize environmental rights as a substantive right. This is not the case in the EU document, the EU human rights instrument. And when you look at the decisions of the court, you also find a divergence of approach. And yet the debate rages on at international law whether or not there is a right to environment at international law. And so you ask, what is international law? At what point do we recognize something to be international law? Because nobody has that debate around procedural rights. Why? Because, like Ethan said, we've got Principle 10 of the Rio Declaration, which then got formalized in the Ahasas Convention. And the Ahasas Convention, of course, is a UNECE convention. It's not an international convention. But nobody debates today whether or not procedural rights are part of the international system. We take it as a given. And yet, we have two instruments from the global south that recognize the right to environment of a particular quality, never mind the debate what it is, and we have that ongoing debate. And so there is a contestation as to what the rule of law is. Whose law? Whose natural justice? Whose international norms? So we have that issue on the one hand. And then on the other hand, in terms of the evolution of some of these conflicts that we find in these research-rich countries, invariably the world gets to know about the conflicts when it hits the international stage. But if we take the Niger Delta as an example, the contestations within the Niger Delta predates 2005, when we all knew about Ken Saro-Wiwa and how he was killed. Indeed, the very first Niger Delta Development Commission was established in 1962. And prior to independence in 1957, the British colonial government set up what was called the Willings Commission to look at some of the issues around marginalization in the Niger Delta region. So these are issues, the underlying, if you like, structures that gave rise then to the further conflict around resource predates what the international community discourses as the Niger Delta problem. And so, in a sense, when we begin to look at what kinds of laws we need to put in place to address the Niger Delta problem, we're looking at, if you like, the consequences, the end product of years, decades of contestations which has not been addressed through any recognized system. So how does law contribute, or how did law contribute historically to the Niger Delta crisis? As I said, when you, of course, oil exploration in the Niger Delta predates Nigeria becoming an independent state. And right at the beginning, the rules, the regulations that were put in place for oil exploration and oil development were colonial laws. And from then onwards, there was never any consultation with the local people or local interests around oil rights, mineral rights in those regions. There was a blanket, in fact, Shell Petroleum at the time had almost universal exploration rights across the entire Niger Delta. Now, that in itself gave rise to contestations around land rights, because the oil belonged to the crown and then eventually to the state when Nigeria became independent, and land belonged to groups, the communities. And so, in essence, right at the beginning, you had that conflict. And UNEP came up with a governance indices in 2003, UNEP, World Bank, and the WRI. And they said there were 7 indices for natural resources governance. One of them was tenure rights, how are land issues addressed? And within that context, land issues were obviously not properly addressed within the context of the Niger Delta. And then the other issue that has become problematic within the Niger Delta is representation. Who represents the people of the Niger Delta in discusses around resolving the problem? Again, the structures that traditionally would have been used were broken down historically within the context of colonialism. So in Nigeria today, including in the Niger Delta, you have 2 structures. You have the traditional systems that the ordinary people recognize. It was interesting, when I was coming on the plane, the guy sitting next to me said, "You're a Nigerian?" I said, "Yes." I said, "You're a Nigerian?" I said, "Yes." He said, "Where are you from?" I said, "Well, when are we going to start asking this question?" He said, "Oh, we'll never stop asking, because in Nigeria, it's the tribe first, and then after the tribe, then the country." And so there are still these traditional allegiances to the local institutions. And yet the local institutions have no recognition within the legal framework. And as the institutions became more and more dependent on the formal laws to sustain themselves, they started to, if you like, become tools for the state forces to use rather than for the interests of their people. And so the whole youth revolution around the Niger Delta evolved from that process, when the youth no longer had faith in the traditional systems because they felt that they were, quote unquote, bought. And so the youth felt they needed to use other mechanisms to try and achieve their goals. So the traditional dispute resolution mechanisms within those systems, of course, became destroyed in that context. And then finally, within the context of history, what you also find is that as these traditional institutions broke down and as the state became, if you like, more, there was this, if you like, disconnect between who the state spoke to and what the issues were at the local level. Because the traditional systems stopped representing its own people. And in that space that was created, you then had, if you like, some of these militant groups taking that space that was created as a result of this gap. And so within the context of the Niger Delta, what are the problems? Am I really saying law is a problem? No, law is not a problem. But that we need to have a much more, if you like, robust understanding of the role that law plays. And that if we must understand how law will address the issues in these areas, how the rule of law can work, we must begin to look beyond, if you like, specific projects to a much more systemic approach to how the Nigerian state engages with the people at the local level. And so when you look at oil laws in the Niger Delta, whether that be around resource ownership, whether it be about around allocation of revenue from resources, whether it be about enforcement of environmental harms, there is a disconnect with the local people. And for a very long time, I spent my time trying to look at how we could address individual laws. So the Land Use Act, there was something wrong with it. Let's address the Land Use Act. But that wasn't the problem. And my thinking is that the fundamental problem is that the Nigerian state has failed to enroll the people of the Niger Delta into the legitimacy of its own laws. Because I think ultimately that's what the rule of law is, that we believe in the rules that are made, and we want to enforce those rules that are made because we believe in them. And that's what the whole idea around legitimacy and legitimation of laws. And essentially, if these laws are not considered to be legitimate, then there is going to be this continuous, if you like, debate around how we circumvent these laws to achieve our ends, to achieve our goals. And in this, I think the international community can play a role. Because, again, I'm sure the Department of Justice representative will know how many cases have come from Nigeria to the US, from around oil resource issues from the Niger Delta. And that is because the institutions at the local level do not provide adequate access to justice. There are rules, there are courts, but whether or not they will give justice is a totally different matter. And this morning, the John Cruden talked about judges and how they can be empowered to actually advance these issues. And I found that really interesting, and indeed it is true, because you found it working in certain areas, especially in South Asia. But in Nigeria, I don't know how many of us know about the Gbemre case, about oil gas flaring in 2006. Federal High Court judge, an activist Federal High Court judge, ruled that gas flaring was a breach of fundamental human rights. And therefore, the Nigerian state and Shell should stop flaring gas. What happened? The judge was transferred from, because it was a federal court, high court, and so they had jurisdictions in several parts of the country. The judge was transferred from the Niger Delta to somewhere in the extreme north, where he will never ever have the opportunity to decide cases like this again, and where his career prospects were, frankly, next to nothing. And since then, for the past 10 years, the case has been tied up in litigation by the corporation in appeals. So it hasn't been enforced. So in a sense, again, back to what I mean about the systemic issues that need to be resolved, that if we must address rule of law issues, it has to go beyond specific laws, specific projects, to the superstructure of how laws are made and how they are implemented within a local system.
Thank you. Please join me. Alan?
Yeah, it's.
Where's the clicker?
I think it's still up there.
Good afternoon.
I never
Let me start by thanking Joel and Nathan for the invitation to participate in this really interesting workshop. I'm going to talk today about alternative environmental management strategies that are sometimes used to try and compensate for weak environmental governance in developing countries. So, first of all, alternative to what? Alternative to conventional regulatory approaches, command and control approaches, economic incentive approaches that require a regulator, first of all, to set rules, then monitor compliance with those rules, and sanction folks who are violating those rules. As we know, that type of approach has a very spotty track record in developing countries where rule of law is weak for a variety of well-known specific reasons. So oftentimes the political will for stringent enforcement is limited. Regulatory institutions are sometimes weak, they're undermanned, they're underfunded. Written regulations are often incomplete and inconsistent. There's a lack of the physical structure, infrastructure that's needed for pollution control, things like municipal wastewater treatment plants, hazardous waste treatment plants. And finally, there's lots and lots of small firms that are difficult and farms that are difficult for regulators to keep track of and difficult for regulators to sanction. Oops. Yikes, what have I done? So increasingly, we see developing countries experimenting with alternative regulatory approaches. And the aim is often to sidestep the constraints that I just mentioned. And so instead of relying on formal regulatory pressure, the idea is that you can rely on pressures from other entities, from communities, local communities who are interested in advancing pollution control and better natural resource governance, from consumers, and from capital markets, from banks and shareholders. And there's three main types of these alternative approaches that I'm going to talk about two of them in a little bit more detail today. They are voluntary regulation, where regulators are providing incentives instead of mandates for improved environmental performance. So those incentives could be positive publicity, they could be regulatory relief, subsidies to pollution control. In addition, there is public disclosure that involves a regulator or a non-governmental organization collecting and verifying and then disseminating information about individual firms and farms' environmental performance. The idea is that's going to ratchet up pressure from these non-regulatory entities. And finally, there's eco-certification that involves trying to create a private sector system of monitoring and enforcement. So one of the principal organizations that's been involved in thinking about how these alternative environmental management strategies work, and in many cases in advocating them, has been the World Bank. Not recently in the last 5 or 6 years, but certainly in the 1990s and in the 2000s. And I thought I'd put up a quote from a World Bank document that was kind of a capstone of their research efforts on these type of initiatives called Greening Markets. And I'll just read it just to give you a flavor of this type of thinking. Overall, the proliferation of innovative channels for reducing emissions has created a new model for pollution control in developing countries. In this model, regulation is information intensive and intransparent. As environmental agencies exert influence through formal and informal channels, they become more like mediators and less like dictators. Community representatives take their place at negotiating table along with regulators and factory managers. Market agents make their presence felt through the decisions of consumers, bankers, and stockholders. So that's interesting and potentially promising perspective, but if you think about it, there's a number of reasons to be at least a little bit cynical about promoting those type of approaches. So for one thing, a lot of the non-regulatory pressures that we've been talking about in some developing countries are relatively anemic. So for example, capital markets in many developing countries are thin and underdeveloped. So you might not expect them to place the same pressure for improved environmental performance on firms and farms that they do in industrialized countries. Consumers, the segment of consumers that are concerned about environmental issues is typically smaller, and environmental NGOs are more scarce and oftentimes less powerful. In addition, there's been a lot of research on voluntary regulatory approaches in industrialized countries, and one of the main lessons, I think, from that research is that those approaches are most effective when there's a strong background threat of mandatory regulation. So the firms that are involved in environmental voluntary regulatory approaches tend to comply with their voluntary commitments when they know that the consequences of not doing that is more stringent mandatory regulation. But that implies that in order for those voluntary approaches to work, a necessary condition is a strong formal regulatory institution. In addition, as we just mentioned, small firms are plentiful in developing countries, relatively plentiful, and you might expect them to be less susceptible to these types of non-regulatory pressures from shareholders and banks than our large firms. And finally, in some developing countries, there are limits on the free flow of information, so you might think that might put a damper on public disclosure approaches. So this is not to say that these type of alternative approaches are never going to be effective and successful, but I think it does mean that it's an empirical question, and we need to understand better whether and under what circumstances these kind of approaches are effective. So what I thought I would do today is just give you just a brief summary of 3 projects that we've done at Resources for the Futures. Resources for the Futures, where I work, we've done a lot of research over the last 10 or 15 years on these type of approaches. I thought I would just take 3 examples. Actually, I'm just going to talk about 2 because I realize I can't fit 3 in. So I'm going to talk about voluntary regulation in Mexico and public disclosure in India. So let me start with voluntary regulation. So voluntary regulation, again, is regulation that depends on creating incentives for improved environmental performance instead of mandates. And again, those incentives could be positive publicity, regulatory relief, subsidies. The 3 most common types of voluntary regulatory approaches are voluntary agreements, which are agreements negotiated between regulatory institutions and representatives of industry. Then there are voluntary programs where a regulatory agency will set criteria for participation in a program, and then firms and farms can opt into that program on a voluntary basis if they wish. And finally, there's unilateral voluntary commitments. So these type of approaches, as you probably know, are pretty widely used in industrialized countries. So in the United States, regulators tend to favor voluntary programs like Energy Star, for example, and in Europe, they tend to gravitate towards voluntary agreements. What's probably less well known is that in developing countries, these type of approaches are also taking off. So for example, in Latin America, environmental regulators in Chile and in Colombia and in Mexico have negotiated hundreds of voluntary environmental agreements with different polluting sectors and agricultural commodity producers. The difference is that in developing countries, voluntary approaches are typically used to try and achieve compliance with laws as opposed to going beyond compliance, which is the goal in industrialized countries. So the stakes for the success of these type of initiatives is higher, in my opinion, in developing countries. So we've done a number of studies of voluntary agreements and voluntary programs at RFF. The first study we did along these lines was a study of a set of voluntary agreements that were used to try and improve environmental management in the tannery sector in central Mexico, in the city of León, which you may know is the leather goods capital of Mexico. So there's about 1,200 tanneries in that city. The vast majority of them are small scale. They have fewer than 20 workers. And tanning basically is this process of taking a cowhide and dipping it in one toxic bath after another, and then trimming it and finishing it. And that process creates all kinds of highly polluting liquid emissions and hazardous waste and solid waste. So this has long been recognized to be a major issue in the city of León and in its environs. Starting in the mid-1980s, there began to be growing demands to do something about this problem that grew out of, at the national level, growing environmental consciousness and the development for the first time of a national environmental legal framework in Mexico. And at the regional level, there was increasing concern about the degradation of Lake Chapala, which is outside of Mexico City. And it was easy to see that one of the major sources of that problem were the tanneries in upstream and the Lerma Chapala watershed in the city of León. So there were, at the time, in the mid-late 1980s, several serious obstacles to making progress with environmental management in León. So for one thing, there were not clear regulations governing what tanneries were allowed to emit, the liquid wastes that they were allowed to emit, and also what constituted hazardous wastes. So there was a lack of a legal foundation for progress. There was also a lack of an institutional foundation. So at this time, Mexico was in the process of decentralizing environmental governance from the federal level, from Mexico City to the states. And it took about 10 years for all of the state regulatory institutions to be set up. And the one in the state of Guanajuato wasn't set up until the mid-1990s. So there was no local regulatory authority to try and take control of the situation. There were also, there was no physical infrastructure. So to deal with this problem, really you needed organic wastewater treatment plants, you needed inorganic wastewater treatment plants, and hazardous waste treatment plants. And none of that stuff existed in the mid and late 1980s. In fact, as of today, the only one type of treatment that exists in the city is an organic municipal wastewater treatment facility. And finally, there was limited pressure from the local community to do something about this problem because tanning was and is the leading employer in the city. So to try and fill that gap, what local authorities did was they got together with national authorities in Mexico City, and they negotiated a series of voluntary agreements with representatives of the tanning industry. And they negotiated a series of 4 of these agreements. The first one was in 1987. The last one was 10 years later in 1997. And the duration ranged from 2 to 4 years. And the terms of all of these agreements were more or less the same. So the tanners promised to install wastewater treatment and hazardous waste treatment facilities in their plants or collective treatment plants. And the regulators, for their part, agreed to provide a grace period where they wouldn't sanction tanners over the course of 2 or 4 years. And they also agreed to get their act together and develop the regulations that tanners would need. And the end result of each of these 4 agreements was the same, which was that neither the tanners nor the regulators kept any of their significant commitments. So what would happen was there would be a 2 or 4 year agreement, and when at the end of that period it was clear that nothing had happened, they would negotiate another one and a third one and a fourth one. Finally, after the 4th one, there was no appetite for a 5th one. But that's basically the story of voluntary agreements in Leon. And after thinking about this and doing a lot of interviews and reading the documents involved, we came to the conclusion that really what happened in Leon was that the same problems that these voluntary agreements tried to address ultimately undermined the voluntary agreements. So as I mentioned, the first issue really was that the infrastructure that would have been needed to deal with this problem had to be built from scratch, and it was hugely expensive. And as a result, the tanners were very unlikely to do anything about this problem unless their feet were really held to the fire. But the regulators didn't have the wherewithal to do that. They didn't have the institutional, the legal basis to do that. So they really didn't have a very credible background threat. And the tanners knew that, and with each successive voluntary agreement that was negotiated, they understood that the consequences of noncompliance were basically zero. And finally, as I mentioned, there was very little pressure from the local community to do something about this problem. So that's the first kind of depressing story that I wanted to tell. I wanted to tell also a less depressing story, and to give you an example of an alternative policy that in my mind has been quite effective, and that's an example of a public disclosure policy. So as I said, public disclosure involves collecting and then verifying and disseminating information about the environmental performance of individual firms and farms, and the idea is that that ratchets up pressure from these non-regulatory entities to do something about environmental quality. So there's basically 2 types of these programs in developing countries. There's pollution transfer and release registries, which basically involve just collecting raw data about environmental performance and releasing that raw data to the public without characterizing it. And this is quite common here in the United States. We have a program like that for toxic emissions. And also in developing countries, there's over 20 of these types of programs in developing countries. The second type are what are called pollution performance evaluation and ratings programs. And these differ in that not only do they collect information on environmental performance, they also characterize environmental performance. And typically the programs place firms or farms into 4 categories: flagrant non-compliance, non-compliance, compliance, and then over-compliance. And so they make these categories very easy to understand. There's often color ratings involved, as we'll see in the case of this program, they assign firms a number of leafs to make it very apparent where firms stand. This is just a list of programs like this in different developing countries. And the one that I wanted to talk about is in India. It's called the Green Ratings Project. It's run by the largest environmental NGO in India called the Center for Science and the Environment. They do these type of ratings for 6 polluting sectors. You can read them there. And they collect very detailed life cycle information on environmental performance, and then they assign a certain number of leafs to each plant, ranging from 0, which is the lowest rating, to 5, which is the highest. So this is just the ratings in the far right column are the number of leafs assigned to the 28 largest pulp and paper plants in India in 1999. And we undertook a study at Resources for the Future. This is the study I talked about before was a qualitative one. This was a quantitative study. We're economists, so we have to do that kind of stuff. And we collected annual data, panel data on environmental performance of 22 large-scale pulp and paper plants from 1996 to 2003. And the question we were asking is, did the 1999 rating, the release of this to the public of information about the environmental performance of these plants, have an impact on their emissions? We were looking at total suspended solids and chemical oxygen demand. And we were using a regression analysis to do that. And in a nutshell, we found that it did, but only for the plants that were relatively poor performing plants. And this is just a graph of summary statistics. It's not a regression results, but it basically tells the story. So the top line, these are emissions of chemical oxygen demand. The top line is for the poorly performing plants, and the bottom line is for the more highly performing plants. The middle line is the average for all of them. And you can see that for the poorly performing plants, there's a big dip in emissions in 1999, the year the ratings were released. And our econometric analysis, we think, verifies that, in fact, the ratings had a causal effect. They significantly cut emissions. And that comports with a lot of evidence that we have about the way these programs work. It's basically most effective for getting poor performers to improve, because for those folks, the costs of improvement are the lowest and the penalties for non-improving are the highest. So I just wanted to conclude with three quick points. I think with regard to these alternative environmental management strategies, obviously they're not a panacea. Some types of policies will work in some situations, but not all policies will work in all situations. With regard to voluntary regulation, I think what our study suggests and what other research on similar programs in developing countries suggests is that just as in developing countries where you need a strong background threat of mandatory regulation to make these voluntary initiatives effective, the same is true in developing countries, which really casts doubt on how effective these programs are going to be in developing countries. And then with regard to public disclosure, I think our study, along with other studies of similar programs in developing countries, suggests that this is a really promising approach. It can really have an impact. That's what I want to say. Thanks very much.
Thanks. All right, we've got a fair amount of time, about 15 minutes it looks like left according to our schedule, to open it up to questions from the floor. Certainly you're welcome to, first of all, there's a microphone that's going to be going around, and then of course you're welcome to either address your question to the panel as a whole or to one of the individuals we've heard from. Yeah, and please also state your name and your affiliation as well when you have the microphone. Looks like we have one back here. We have a number of them. I'll try to get to them all, but we'll start there.
Hello? Oh, there it is. Hi, my question is for Alan Blackman. Since you just spoke about it, and my question is well timed, I just wanted to ask you, what other variables did you consider in looking at the effectiveness of ratings on Indian, I'm trying to remember what they were.
Pulp and paper plants.
Pulp and paper plants. And did you follow up with field work to understand why it was the ones who were the worst polluters for which it had the greatest effect? Thank you. And I'm Ben Allen from Billingsley Research.
Well, the project was joint with the Center for Science and Environment, so they kind of collaborated with us in doing it. And so to the extent we did field research, it was in working with CSE. With regard to your first question of what did we control for, so basically we tried to control in our econometric analysis for all of the variables, the potentially confounding variables, the things that might have explained changes over time in the emissions of chemical oxygen demand and total suspended solids. And I'm not sure everybody's going to be interested in this. I'll be glad to run through what those were. But basically, we controlled for a bunch of time-varying things, and then we included fixed effects to get at all the time-invariant confounders.
Another question on the right here.
I'm a little confused. You said that a precondition for these to work, the voluntary agreements, was strong background regulation. But if you say the goal is just to get standard compliance, not over compliance, it's a little puzzling, right? Because if you had strong background regulation, they would be complying. So then why do you need a voluntary agreement if there's strong background regulation?
That's kind of, in my view, the flaw in the logic for how you can use these things to improve environmental compliance in a developing country where there's not very strong regulatory pressure, and most firms are not in compliance.
So then in places where we do have the strong background, you could use them just for over
That's correct. Yeah, I think that's the lesson. That's the conclusion of most people that have studied voluntary approaches in industrialized countries, is that they are effective in getting firms to over-comply when there's a strong background threat, when firms understand that if they don't improve their environmental performance, that there's likely to be regulation coming down the road that's going to force them to do that.
Right. If I understood you right, Alan, it's not just that there's strong regulation in place today. It's that there's a sufficiently strong regulator that could threaten it in the future. We'll do this voluntary agreement today, and if there's a credible threat that there would be regulation in the future, even if it's not in place today, then that voluntary agreement might work.
It's great to have a lawyer to like.
Well, I'm just translating for you.
Yes, that's what I mean. Thank you.
Thank you.
Let's take another question. We got one in the back there on the left, or on your right, my left.
Thanks so much to all the panelists. My name is Sarah Danish. I'm with International Republican Institute. My question is probably directed at Ngobo. Is it Emesa? Yeah. But I welcome any other comments from the other panelists. It's about citizen engagement. In the Niger Delta situation, maybe this opens up a book for citizen engagement. What does effective citizen outreach look like? And what I mean by that is consultations with the communities. You know, who does it? What resources are involved, human and otherwise? And any anecdotes at all you can share on what successful engagement with community actors looks like to help to turn the situation around. That would be much appreciated. Thanks.
Thank you. There's been a lot of evolution on that front. When I was in Nigeria, you used to find consultation programs or processes where people like me would be invited to, and then you'd have a local representative, would be a chief who may not have consulted his people, and then everything will be decided in one of the cities, Port Harcourt, without going down to where the local people are actually are. And then you find that there is, again, not actual participation from the local people. However, there's been quite a lot of movement in recent times because of civil society groups. You find that the NGO sector has been very, very active in trying to mediate that gap between communities and other stakeholders, the bigger actors, the state, the corporations. However, even within that context, you have a challenge because, of course, as we know, NGOs do not have a mandate. And so how do NGOs, if you like, navigate that difficulty around representation? And that goes back to what I said in my presentation, which is that there were traditional systems for who ought to represent local communities. However, that's been broken down. And then at the formal level, you've got the local governments who the people have no faith in or trust in. And so in a sense, actually, the question you asked is a really good one, because one of the biggest problems you have is how do you get people, representatives that the people trust to to negotiate on their behalf around these issues. That's a huge, huge challenge.
So really interesting question, and it's one that we at EPA and the federal government generally deals with respect to our indigenous populations and Native American Indian tribes. On the one hand, we want to respect the tribal structure and the tribal customs and the government-to-government relationship that we have between the U.S. federal government and the Indian tribes as tribes. And so when we consult on a formal basis, we consult with the leaders of the tribal governments. But what happens when there's a significant portion of the population or the community that doesn't believe that those tribal leaders are effectively representing them, or have other views, and they're just as affected by the problem? And so we have, at EPA, we have both a formal tribal consultation policy where we respect the tribal system of government and consult on a government-to-government basis. But then we also have an environmental justice policy that recognizes that any community that's disproportionately affected by pollution and that hasn't traditionally had a voice will have the opportunity to have their voice heard. And so sometimes when we consult in indigenous communities or in communities in those areas, we are consulting at multiple levels to make sure that that all of the voices are heard, and at the same time we're sort of respecting their internal governmental structures. But it can be tricky.
In the back, I guess not all the way in the back. I'll get to you next, but yeah, you.
Actually, just to ask a follow-up question on that, you mentioned, sorry, I'm Aiden from Eco Agriculture Partners. Ethan, you mentioned consulting at multiple levels of tribal governance. How does that impact your negotiations at those multiple levels? If you're talking with tribal leaders and you're negotiating with the groups below tribal leaders in those governments, how does it impact your credibility with either or in those situations? Or does it have a negative impact?
Well, first of all, we're not necessarily negotiating. So, for example, in a rulemaking process, we're not necessarily negotiating our rule with state and local governments or stakeholders or tribes. So that's not really what's happening. Instead, it's really a process of gathering input and just giving various groups and organizations of groups and communities a voice in the process. And that sometimes has to take place at multiple levels. Sometimes when we're talking about rulemaking, we will have a public participation process where anyone can comment on a rule, and that's a very significant part of the process. We'll have a tribal consultation where we're having a government-to-government consultation with tribes and getting input that way, but then we'll also have special opportunities for environmental justice communities also to be heard and to have a voice. And I guess I would say that our overall approach is the more input, the better. And we don't see it as necessarily a negotiation where we have to bring everybody to sign the dotted line and come to resolution. But from our perspective, the more input, the better.
All the way in the back.
Hi, my name is Dimitri. Thank you very much. Very interesting discussion, and I apologize in advance if this is not really a legal question. I don't know much about law, but my question is for Mrs. Benke I apologize if I mispronounced your name. Is that, how do you say it, sorry? Beneke, excuse me. So you've been with UNEP not very long, and I guess you were in the federal government for a long time. And if I remember correctly, in the State of the Union, the United Nations nor the Sustainable Development Goals were mentioned at all. So I'm wondering, and I would guess that this is in the U.S. population, the amount of people that know about the Sustainable Development Goals probably 5% or less. The climate deal probably more. So in your opinion, what would it take to get the U.S. population more behind the Sustainable Development Goals?
Well, I guess for starters, I think the numbers indicate that the U.S. population is behind the United Nations, generally speaking. There is data and information to that effect and supportive of the role of the United Nations. I think one of the reasons I'm here today is to talk about the Sustainable Development Goals. The administration has committed to carrying out and supporting the Sustainable Development Goals. One in particular that has been highlighted by the administration is a Sustainable Development Goal and target having to do with sustainable consumption and trying to greatly reduce food waste, for example. There are some of these goals that make sense to try to implement domestically, and that one in particular is an important one. In the U.S., about a third of the food that is grown is wasted, and most of that occurs, as I understand it, between the consumer and the landfill. In other parts of the world, there's a lot of food waste between harvest and market, but in the developed world, it's more between market and landfill. So, I do think that there's general, I commend all of you reading the Sustainable Development Goals. It's hard to be against trying to eradicate poverty globally. It's hard not to support the idea of eliminating hunger. All of the goals are pretty lofty and kind of mom and apple pie, truthfully, but certainly worthy of people pulling behind and supporting. And I think in the United States there is good support. I don't know that there's a lot of public awareness yet, but that continues to build.
All right, thank you, everyone. We're very close to the end of our session. I want to keep us on time. We have one session following this one, which, if I'm interpreting the schedule correctly, does follow right on from this one. But I hope you'll join me in thanking all of our panelists. Certainly thank you for taking your time.